The last case to come before the court is State versus O'Malley. And in this case, appellant will be solely arguing by himself, so you have your 15 minutes.
Thank you, Your Honors. May it please the court. What brings us here today is a constitutional challenge as applied to Mr. O'Malley with respect to the forfeiture of his vehicle after his plea and conviction on the third OVI within 10 years. What brought this appeal about was the United States Supreme Court recently issued a unanimous decision in Indiana versus Timms, which was probably long overdue, but it finally officially applied the Eighth Amendment to the states through both the 14th Amendment due process clause as well in the concurring opinion. They applied to the states through the privileges and immunities clause. What is very interesting about Timms historically is it involved a forfeiture of a Range Rover which was valued at $42,000. This is a state of Indiana case, and that was forfeited during a drug trafficking offense. The Court of Appeals in Indiana stated that since the max fine for the drug trafficking was $10,000, the vehicle was $42,000, that a 4 times multiplier of max fine versus value of the forfeited vehicle, they said that that was unconstitutional as it was an excessive fine. The state Supreme Court in Indiana reversed the appeals court, stating that the Eighth Amendment doesn't apply to the states. So that's how it got to the United States Supreme Court, and the case is currently back in the state of Indiana to make its final determinations. I think that's particularly instructive in this case, as we're dealing with a third OVI. The maximum fine for the third OVI is $2,750, and the vehicle forfeited in this case was valued at in the $30,000 range. The defendant, Mr. O'Malley, testified that his vehicle was worth about $38,000. I think the trial court ended up determining that the vehicle's value was $31,000. So we're dealing with basically a 12-time multiplier of max fine versus the forfeited vehicle's value. To criticize the trial court's opinion here, the Indiana versus Timms decision was made in February of 2019. The trial court's decision in this case was made in March of 2019. And interestingly, the trial court did not apply any federal law to this case. It didn't apply the Eighth Amendment at all. There is a case that is pretty much the seminal case on forfeitures and the Eighth Amendment, which is United States versus Bahakajan. That case set forth a 4-part test that courts are supposed to analyze when determining whether a particular forfeiture is unconstitutional and an excessive fine. The trial court in this case didn't apply Bahakajan at all. It applied a state case test. So as far as the 4-part test is concerned for Bahakajan, and the trial court should have applied that, what our main challenge is to the third prong of the Bahakajan test, which is the court is supposed to analyze the maximum fine versus the amount of the forfeiture. Now there's a couple different, some federal case law that should have also been applied by the trial court, and one of those is United States versus Speranza, which was cited in my brief. And why we cited to Speranza is it sets forth kind of different tiers of analysis that the court needs to go through when it's determining whether a particular forfeiture is excessive. So Speranza says that if the forfeiture value is within the maximum fine range, then it's presumptively constitutional. It also says that if the forfeiture value is a little bit above the maximum fine, then there is, and I think the word they used was, it's to receive closer scrutiny. And then Speranza finally said, they set forth a third tier, which said that if a forfeiture is grossly in excess of the maximum fine, which I argue is the case here, that the forfeiture is likely unconstitutional. So what that says to me is that U.S. versus Spranza thinks that there's almost a presumption of unconstitutionality if the value of a forfeited vehicle is way above the maximum fine, which I think is the case here with our 12 times multiplier. So, you know, I'm asking the court today to pay very close attention to the historical analysis in Indiana versus Timms. The court goes through and almost sets forth a general framework that courts in general are supposed to view forfeitures and fines with great skepticism because they benefit the state. Forfeitures and fines go into the revenue of the general revenue of the state, and because of that, they should be viewed with intense scrutiny, and that's said specifically in Indiana versus Timms. For further comparative purposes, in U.S. versus Bahakajan, you know, in that case there was a $350,000 forfeiture versus a $5,000 max fine. The court in that case actually reduced the forfeiture down to $15,000, which would be a 3 times multiplier. And there's a number of other cases, federal cases, which have said that lower multipliers, such as 1 time, 2 times, 3 times the max fine is okay. But now we're dealing with a 12 times multiplier here. Now, aside from the fact that this forfeiture itself is unconstitutional under the 8th Amendment, that problem is compounded by the fact that this is also unconstitutional under the Equal Protection Clause of the 14th Amendment. Judge Hensel, I believe you were on the panel 2 weeks ago where I argued this point in front of that panel. But just to go over that quickly, the statutory scheme here under the OVI statute sets up a situation where if you own your vehicle when you're committing a third DUI within 10 years, you are subject to forfeiture. It's mandatory. The court has to order it. And you're also subject to a mandatory 5-year registration ban where you cannot register a vehicle in your name for the next 5 years. So that's that particular class of people. Now, if you commit the exact same offense under the exact same circumstances and you do not own your vehicle, then you are not subject to forfeiture and you are not subject to the registration ban. So that's setting up a situation where we have 2 identical people committing the same crime, they're in the same situation, and the state of Ohio is treating non-vehicle owners one way and treating vehicle owners another way. And right there is where there is an equal protection violation. Now, in analyzing an equal protection challenge, in this case it's going to be rational review. So the question for the court is, what state interest is rationally related to why they're treating these 2 people differently? And I argued that there is no rational reason to treat a non-DUI or a non-vehicle owner DUI differently than a vehicle owner DUI. Vehicle forfeiture is an enormous penalty. It often involves a vehicle which is valued at thousands or even tens of thousands of dollars. It's a huge penalty, and there's a lot of disparate treatment between somebody who's completely escaping that versus somebody who has to sustain that penalty. I presume, the state of Ohio isn't here to say so. I presume that the reason that the state of Ohio put this forfeiture provision into effect is to prevent recidivism. So I think the key question here and what this entire thing boils down to is, how does allowing a non-vehicle owner to completely escape a punishment, how does that advance the state's interest of recidivism? It doesn't. A non-punishment can never incentivize somebody not to commit future conduct. And in the last section of my brief, I reference a couple other sections of the revised code where the state actually can fine somebody, or the judge can actually fine somebody in the amount of their vehicle. So to give the court an example of how that would apply, if you're subject to forfeiture, you own your vehicle, your DUI case is pending. If you try to sell your vehicle or dispose of it some way to try to avoid the forfeiture penalty as an end around, the law gives you the ability to, gives the judge the ability to fine the person in the amount of the vehicle. So I'm proposing to the court that in order to make this scheme constitutional, the court should also have the power to fine somebody who's driving a third-party vehicle fine them in the amount of the value of the vehicle. And then that would equalize the punishment between the two parties. On the one hand, if you own the vehicle, it's going to be forfeited. If you don't own the vehicle, you're going to get a fine in the amount of the value of the vehicle, no matter who's driving it or who owns it. So, based on that, I'm asking the court to declare the forfeiture in this case unconstitutional as applied to Mr. O'Malley, based on it, that it's an excessive fine in violation of the 8th Amendment. And I'm also asking the court to completely strike down the forfeiture scheme in the OVI statute as a violation of the Equal Protection Clause under both the 14th Amendment and the State of Ohio Constitution's Equal Protection Clause.
No more questions, so thank you for your presentation to the court. We will take it under advisement and issue a written opinion that we send to both sides, as well as released on our website.
Thank you, Your Honors.